petitioner and senior counsel Shri Pramod Nair representing the second respondent complainant.
One just a minute, man.
Yes,
Not take more than a minute. Witness summons ಬರ್ತಾನೆ ಎಕ್ಸಾಮಿನೇಷನ್ ಇನ್ ಚೀಫ್ ಆಗುತ್ತೆ, ನಿಲ್ಲಿಸ್ಬಿಡ್ತಾರೆ 3 ಸಾರಿ. ಆ ರೆಕಾರ್ಡ್ ಬೇಕು, ಈ ರೆಕಾರ್ಡ್ ಬೇಕು ಅಂತ. They must keep themselves ready when once the trial commences. That is what the Supreme Court has said.
yes. Even in the latest judgment, they should be ready on it for a day-to-day basis.
ಮಾಡೋದಿಲ್ಲ. ಆಮೇಲೆ next day, the court would direct the prosecution to keep that witness present the very next day, so that his examination in chief is concluded, cross-examination is done. ಕೋರ್ಟ್ ಕರ್ಕೊಂಡ್ ಬರ್ತಾರೆ, ಕೆಳಗಡೆ ಕೂಸ್ಕೊಂಡಿರ್ತಾರೆ ಅವನ್ನ. ಬಂದಿಲ್ಲ ವಿಟ್ನೆಸ್ ಇವತ್ತು ಅಂತ ಅಂತಾರೆ. ಅರೆ ನಾವು ನೋಡಿದ್ವಲ್ಲಪ್ಪ, ಬಂದಿದ್ದಾರೆ ಮಿಸ್ಟರ್ ನಾಯಕ್ ಅವರು, ಹಿ ಇಸ್ ಆಲ್ಸೋ ದೇರ್. ಈ ಸೆಡ್, ನಾನೇ ನೋಡಿದೆ, ನಾನು ಮಾತಾಡ್ಬೇಕು ಅಂತಿದ್ದೆ, ಮಾತಾಡ್ಲಿಲ್ಲ, ಹೆದರ್ಕೊಂಡು ವಿಟ್ನೆಸ್ ಹತ್ರ ಏನಂತಿರೋ ಅಂತ. ಬಟ್ ಸ್ವಲ್ಪ ದಯವಿಟ್ಟು CCTV ಕ್ಯಾಮರಾ ಇದೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಅದನ್ನ ಕರೆಸಿ ಐವೋ ಜೊತೆ ಬರ್ತಾರೆ, ನಾ ತೋರಿಸ್ತೀನಿ ಅಂತಂತಾನೆ. ಅವಾಗ ಐವೋ ಓಡೋಗ್ಬಿಡ್ತಾರೆ, ಅದನ್ನ ಅಲ್ಲಿ ಇರೋದೇ ಇಲ್ಲ. ಆಮೇಲೆ ಏನಾಗ್ತಾರೆ, ನೋ ಇದೆಲ್ಲ ಮಾಡಬಾರದು, ತಪ್ಪು, ಎನಿವೆ ಐ ವಿಲ್ ಇಶ್ಯೂ ಎ ಬೇಲೇಬಲ್ ವಾರಂಟ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್ ಅಂತ. ವಿಟ್ನೆಸ್ ಅಲ್ಲೇ ಕೂತಿರ್ತಾನೆ ಬೆಂಚ್ ಮೇಲೆ ಆಚೆ ಕಡೆ. ವಿಟ್ನೆಸ್ ಓಡ್ ಬರ್ತಾನೆ, ನನಗೆ ಯಾಕೆ ವಾರೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ, ನಾನು ಇಲ್ಲೇ ಇದ್ದೀನಿ, ಅಯ್ಯೋ ನಾನು ಹಿಡ್ಕೊಂಡು ಕೂತ್ಕೊಂಡಿದ್ದಾನೆ, ಇಲ್ಲಿ ಕೋರ್ಟ್ ಒಳಗಡೆ ಹೋಗ್ಬೇಡ ಅಂತ ಅನ್ಬಿಟ್ಟು ಅಂತ. ಇದೆಲ್ಲ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಗೊತ್ತಿಲ್ಲ ಇದು. ಸೊ ನಾವು ತಳ್ತಾ ಇದೀವ ಅಲ್ಲ, ಇವ್ರು ನನಗೆ ಅಪೋನೆಂಟ್ ಅಲ್ಲ.
ಸೇಮ್ ಜೊತೆನಲ್ಲೇ ಇದೀವಿ.
ಈ ಕಡೆ ಯಾಕೆ ನಿಂತಿದ್ದೀರಾ?
ಜಾಗ ಇರಲಿಲ್ಲ. ಇಲ್ಲ, I filed that application before the trial.
The legal issue which I have raised for my lord's kind consideration is merely because he makes a prayer for an order of reference under 156(3), it does not mean that ipso facto the magistrate has got to pass an order.
Correct.
Even for the purpose of passing an order of reference, just like issuance of process 204, or for the purpose of taking cognizance of 190, what is needed is a little application of judicial mind on the part of the magistrate.
All right.
No, but may I just request your lordship to kindly attend to the order that is passed by the magistrate. What he says is, there has been a compliance with the requirements of law as mandated by the Supreme Court under in that Priyanka Srivatsava. Therefore, I am passing an order of reference. That is incorrect. May I request your lordship to kindly turn to, this is the first legal submission which I am making.
If that is a submission, we'll send it back. I can't wash the matter on that ground. Non-application of mind, I will right away send it back.
ಒಂದ್ಸರಿ ಓದ್ತೀನಿ ಇದನ್ನ.
ಏನು ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ, ಯಾರಿಗೆ ರೆಫರ್ ಮಾಡಿದ್ರೆ ಆಫೀಸ್ಗೆ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ಅವ್ರ ಆಫೀಸ್ಗೆ
ಆಫೀಸ್ ಇಸ್ ಡೈರೆಕ್ಟ್.
Office is directed to register case and investigate.
Classic illustration of non-application of
156(3), order 155(2). Otherwise, no. Merely because there has been a compliance, he can't refer it.
We'll send it back. You can come back.
Leaving open, my lords.
Yes, all contents. Right away. Yes.
Civil suit dismiss ಆಗೋಗಿದೆ ಅವರದು.
ಅದೆಲ್ಲ ನೋಡ್ಲಿ ಅಲ್ಲ. The petitioners ಅಲ್ಲ, the petitioners accused 1 and 2 are before this court, calling in question an order of the learned magistrate dated 30th April 2024 by which he refers the matter for investigation under 156(3) of the CRPC. Heard the learned senior counsel Shri C. V. Nagesh appearing for the petitioner and senior counsel Shri Pramod Nair representing the second respondent complainant. The petitioners and the respondent complainant are siblings, huh?
Yes, sir.
Are siblings and are in a squabble on several.
First petitioner is the mother. Second petitioner is the brother of the respondent. Second respondent.
This is all family members. The first petitioner is the mother of the second petitioner and the complainant. Therefore, the second petitioner and the complainant are siblings. They have a squabble over certain issues, which has led the second respondent complainant before the concerned magistrate, invoking section 200 of the CRPC. Second round.
In the first round, the petitions would question the legality and correctness of registration of the crime and would seek for the quashing of the FIR. And this honorable court, having felt that the allegations made in the complaint warrant an investigation, let there be an investigation, and this honorable court,
My order.
Your lordship's order. And after the completion of the investigation, a final report in the form of a charge sheet is filed. And on the strength of that charge sheet, my lord, the court is said to have taken cognizance and ordered process against the petitioners. Now, may I request your lordships to kindly turn to ink page 552.
552.
552. That is the proceeding sheet. If this appeals to your lordship, probably I need not disturb your lordship on the merits of the matter.
Cognizance order,
ಹೌದು. My lord, in the latest judgment of the Supreme Court, what the Supreme Court has said is application of judicial mind for the purpose of 190 is totally different from application of judicial mind for the purpose of issuance of process under 204. That is all, my lord, in Vikas and in Vikas Court.
That's my respectful submission would be, this is the order of cognizance which my lord is seeing at 552. Now, this is a case post-investigation, charge sheet filed, and on that basis.
No problem.
Now, the difference, as my lord should repeatedly point out, if it is going to be a complaint under 200, while taking cognizance, the application of mind, disclosure of application of mind is more, because my lord, there is no investigation.
204 is the only provision which permits issuance of process.
Out.
Expert says, no, it is not possible.
Anyway, we'll see that, my lord. So on a question of fact, on merits,
My lord,
I will not enter into
30
merit.
charge sheet witnesses, 4 and 6
My lord,
times, if it's
wait,
going on the
wait.
merits of
It's an
it.
offense of forgery. When the matter is referred to an expert for examination and report, there should be two types of positive opinions. Number one, it is not the complainant signature or the writing. Number two, it is the signature or the writing of the accused. What should be in positive? Well, what he says is, it is not the signatures of the complainant, but he does not say that I have forged it.
Yeah.
I should show you. Please.
He is bought back under 319?
I'm sorry, my lord.
He is bought back under 319, is it?
Well, more than anything else, my lord, the procedure that is adopted by the learned trial judge is unknown to law. I shall just give your lordship a few facts, my lord, in just 2 or 3 sentences. Well, the final report in the form of a charge sheet came to be filed against the petitioners complaining of the commission of an offence under section 302 IPC, among other offences. All of them are on bail. Well, the trial went on. Charges came to be framed. Petitioners pleaded not guilty. Trial went on. Nearly about 65 witnesses came to be examined. Then, my lord, the prosecution would close its case or side. Thereafter, the trial court would post a matter for recording of the statement of the accused under section 313. Statement of the accused also came to be recorded. Then it was set down for either for defense evidence or for hearing final arguments. It was at that point of time, my lord, a writ petition came to be filed before this honorable court seeking for further investigation at the hands of some other agency. But that writ petition came to be dismissed by this court. But the aggrieved would take up the matter before the Supreme Court in a special leave petition. That also came to be dismissed. In the meantime, they would also make an application before the benign government seeking for an order for further investigation. But what the government does is, in exercise of the powers said to have been clothed upon under 173(8), though it is not so, it is only a power that is clothed upon the investigator, not upon the state government. If my lord were to read section 173 subclause 8, however, my lord, the fact remains that the government would order for further investigation.
Government orders.
Government orders further investigation despite the dismissal of the writ petition and also the special leave petition by the Supreme Court. Doesn't matter. But further investigation came to be taken up. Additional
That's
report.
5 years ago.
Yeah.
Further investigation order is 2019.
Yes. But the issue is this. Let them file. Doesn't matter. I was aggrieved, my lord. Subsequently, I filed. Additional report came to be filed. It can't be a supplementary charge sheet or a fresh charge sheet. It is only a report which is additional to the report that has already been filed. That is how, my lord, the language of section 173 8 says. My lord, well, have a look at section 173 subclause 8. It can't be a fresh charge sheet or a supplementary charge sheet. It is a report which is filed in addition to the report that is already filed.
What do you say the report?
Well, yes, I shall come
The
to that.
charge sheet filed under 173(2) is also termed as a final report.
Quite right.
The same way, this is also a report.
Yes, my lord, that is exactly what I'm saying. Now, have a look at 173 subclause 8, my lord, for a
Yes.
second.
Yes.
Although my lord would be coming across the day in
Yes,
and day
yes.
out. Just for my satisfaction, let me invite
Yes,
the
sir,
lord's
yes, yes.
kind attention. Let me not
Yes.
be mistaken, my lord. Nothing in this section shall be deemed to preclude further investigation.
Hmm.
Yes, my lord.
Yes,
In respect of an offence, after a report under subsection 2 has been forwarded to the magistrate, and whereupon such investigation, the officer in charge of the police station obtains further evidence,
Hmm.
oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form. That means it will be a further report to the report that has already been filed.
Hmm.
No quarrel about that.
yes,
issue.
sir.
And a further report has been filed.
Hmm.
Immediately with the trial is likely, trial has already been over. Trial has come to an end. It is a case where the trial is yet to commence. Well, 216 subclause 4
Hmm.
comes into play, or it could be pressed into service, provided the trial has not commenced. Here in the instant case, trial has already commenced. That means recording of evidence is almost over. 65 witnesses have been examined. Now, my lord, charges came to be altered or added. Then, my lord, the procedure which the trial court is required to follow is under section 217, not under section 216(4).
Recall of witnesses.
Yes, my lord. Chapter 18, no sooner the final report is filed, under 226, my lord, the prosecution is required to state its case.
Yes.
227, my lord, the accused can make his submissions for an order of discharge. 228, the court can proceed to frame the charge.
Hmm.
Thereafter, my lord, 229, 230 evidence, recording of evidence. That means, again, my lord, reopening of the case for a fresh trial. It can't be done. That is the law. Next time, he would file another list of witnesses.
Repeating those very.
No, some
You-
other persons. Well, that is what the Supreme Court has condemned. May I just invite my lord's kind attention to the judgment of the Supreme Court.
So according to you, 217 permits recall of the witnesses and not bringing in new witnesses. In a case where it is under 216(4).
Yes.
Yes.
Well, to see, subject to what my lord would ultimately say.
Yes,
216(4) is only in relation to a case where the trial has not commenced.
that we'll see.
Here, the trial has commenced.
No, 216 deals with alteration of charge. Now, alteration of charge, commencement of commencement of trial or conclusion of trial has nothing to do with alteration of charge. It can be altered at any time,
Anytime it could
at
be.
any time.
As my
The
lord has.
procedure after that is under 216(4) and 217 is what we'll consider it. Yes.
What has? However, the witnesses concerned may be bound down, etc., etc. But here he files a list of witnesses. First day, second day, some other witnesses, third day, some other witnesses, and he does not even summon or secure the presence of a witness who has been examined in part.
No, now we'll have to answer. What is the purport of the word new trial in subsection 4 of section 2 and 6? If that is taken note of, then whether witnesses can be brought in afresh.
I
The
was
Supreme Court direction is not there to conclude.
no Supreme Court direction, nor the direction of this court. I was the one who argued the matter. What this honorable court has said is, we request the trial court to dispose of the case itself within 3 months. Anta. Request the court. anta,
Request by a higher court.
ಮತ್ತೆ
As good as a direction.
ಆಯ್ತಲ್ಲ, at
ಅಲ್ಲ,
his
ಅದ್ರ ಮೇಲೆ
instance-
Supreme Court judgment
ಅಲ್ಲ,
ಇದೆ, ಅದೇನು ನಾನು
at
ಹೇಳೋ
that
ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
request, at his instance, the matter is urgent more than 3 months.
Not
Now keeping
me.
the witnesses present,
Somebody.
third list, fourth
But
list.
what is this procedure?
I'll just not check. I do not know. I am not representing. Not a-
True,
ಅಲ್ಲ,
but how is this?
ಏನು ಅದೇ ಪ್ರಸನ್ನ ಈಗ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಸಪೋಸಿಂಗ್ ಯು ರೆಕಾರ್ಡ್ ಇಟ್ ಆಸ್ ಎ ಫ್ರೆಶ್ ವಿಟ್ನೆಸ್ ನಾಳೆ ಮತ್ ಪುನಃ ಅದನ್ನ ಇಫ್ ಇನ್ ದಿ ಇವೆಂಟ್ ಐ ವರ್ ಟು ಸಕ್ಸೀಡ್ ಬಿಫೋರ್ ಯು ಲಾರ್ಡ್ಶಿಪ್ ಬೀಯಿಂಗ್ ಪರ್ಸ್ಯೂರ್ ಟು ಆಕ್ಸೆಪ್ಟ್ ಮೈ ಸಬ್ಮಿಷನ್ಸ್ ಅದು ತಪ್ಪಾಗಲ್ವೇ ಅಂತ ಅಷ್ಟೇ ಇದೇನಿಲ್ಲ
Then you take a week's time. I will defer this by a week.
ಅಷ್ಟೇ ಅಂಡ್ ಜೊತೆ ಇನ್ನೂ ಒಂದು ಲಿಸ್ಟ್ ಹಾಕ್ಬಿಟ್ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳ್ತಾರೆ ಫಸ್ಟ್ ಐ ವಿಟ್ನೆಸಸ್, ಆಮೇಲೆ ಸರ್ಕಮ್ಸ್ಟಾನ್ಷಿಯಲ್ ಎವಿಡೆನ್ಸ್, ಆಮೇಲೆ ಎಕ್ಸ್ಪರ್ಟ್ ಎವಿಡೆನ್ಸ್, ಆಮೇಲೆ ಮಿಸ್ಲೇನಿಯಸ್ ಎವಿಡೆನ್ಸ್ ಏನಾದ್ರು ಇದ್ರು ಮಾಡಿತ್ತಂದ್ರೆ ಫಸ್ಟ್ ಇವ್ರು ಕರ್ಕೊಂಬರೋದು ಯಾರು ಅಂತಂದ್ರೆ ಗೋವಾದಲ್ಲಿ ನಾವು ಅಲ್ಲಿ ಭೇಟಿ ಮಾಡಿದ್ವಿ ಅಂತ.
Miscellaneous evidence.
ಹೌದು, ಐ ವಿಟ್ನೆಸಸ್ 7 ಜನ ಇದ್ದಾರೆ, 7 ಜನಕ್ಕೆ ಲಿಸ್ಟ್ ಕೊಡ್ತಾರೆ, 7 ಜನಕ್ಕೆ ಸಮನ್ ಸರ್ವಾಗತ್ತೆ, 7 ಜನ ಕೋರ್ಟ್ ಮುಂದೆ ಬರ್ತಾರೆ, ಮಾಡೋದಿಲ್ಲ. That is unfair.
No, all that we will lay down. What is to be done?
Please,
Yes.
please.
Because the criminal trials judgmentally, Supreme Court says what is to be done in
This will be
trial.
a guidance. Your lordship's order in this case, being a law, my lord, this would be a guidance for the trial court, what procedure they need to follow in a situation of this